A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. I'm so glad you've joined us on the program today. Coming up in a matter of moments, we're going to be talking with Amy Swearer of the Heritage Foundation, attorney and Second Amendment specialist over there at Heritage. Yeah, we're going to keep the conversation going about the Supreme Court accepting New York State Rifle and Pistol Association versus Corlett. We spoke yesterday on the program with Tom King, head of the New York State Rifle and Pistol Association, just a couple of hours after the court had granted cert in this case. But I want to talk with Amy about some of the lingering questions around the court's decision for why did they take so long? I mean, they relisted this case for this was, I think, the fourth relist before they granted cert. Why did they change the question that was presented? The plaintiffs asking the question, does the Second Amendment protect a right to carry a firearm outside of the home in self-defense? And the court decided, well, actually, that's not the question we're going to answer. We're going to tweak that question a little bit. Okay, what's going on with this? Now, look, I wish that Amy had the inside skinny, that she had connections and she was talking to justices and their clerks. That's not the case. But what Amy does have, I think, is a very sharp legal mind and some pretty good working theories as to what might be at play here. So we don't know for certain why these things happen, but we can explore the possibilities in our conversation. That's exactly what we're going to do. Take a look and listen. Amy Swearer, thank you so much for coming on the program. It's so good talking with you today.
Yeah, thank you so much for having me. Always great to be on with you.
Well, and again, it's good to be talking about some good news for once, and not Biden's executive orders or the gun control bills passing out of the House of Representatives. Now we get to talk about the Supreme Court accepting a case dealing with the right to carry. But I want to get into this with you because obviously there are a lot of folks out there who are still, let's say, skeptical that the court is going to save or secure the Second Amendment. We saw last year the court allowed New York City to moot a challenge to its gun control laws. We saw the Supreme Court. This is before Amy Coney Barrett was on the bench, to be fair, but we still saw the court, hold on to almost a dozen Second Amendment cases for weeks and weeks and weeks, raising our hopes, and then they denied certain all of them.
All of them, yeah.
Right. So there was this expectation, I think, as we saw the court hold on to New York State Rifle and Pistol Association versus Corlett for several weeks. Oh, God, they're going to do it again. No, yesterday they grant cert. So first of all, let's just start there. I mean, what is your take on the fact that the court did accept this case when they've turned away some other significant challenges this year, particularly to prohibited persons? In fact, yesterday they turned away another challenge to a gentleman who was 17 when he was involuntarily committed to a mental institution. Yeah. He has had his rights restored by the state of Washington, but he can't get his federal rights restored. This, to me, seems like it would be a pretty good challenge, but the court turned that case away as well.
Yeah. It's funny. I actually remember probably about a year ago was when we were sitting here talking about, man, they just dismissed or denied all of these cases. I can't wait for us to have, a conversation where it's a happy grant. And, a year later, here we are finally. But it's not shocking to me that there are some hesitations and some sort of naysayers out there who are skeptical of what the court's going to do here. Precisely for some of the reasons you mentioned. I mean, yes, we have a changed dynamic in the court. We have a new justice in Justice Barrett, who I think has given us a fifth solid Second Amendment justice, at least based on some of her earlier opinions. But there were just some weird things with this case. I mean, you had it being relisted several times instead of taken right away. Even with the grant earlier this week, there was some changing of the language to the question that they were actually going to decide on. So there were some weird anomalies. Who knows what those could be? I think at the end of the day, the court did what the next step had to be. I mean, realistically, the Second Amendment framework is so minimal right now. Between Heller and McDonald, I think realistically, the next step to building that out had to be a public carry case or some sort of, assault weapons ban case dealing with the types of firearms that are protected. So it was a weird way of getting here. It was a long way of getting here. But I think, given the change dynamics of the court, here is where here had to be, if that makes sense. I think this was always going to be the next issue for the court. And even just given the facts of this case, I think this is a much harder case to moot out, to find ways to get rid of if you're the state. So I think there's a much better chance of this one sticking. And I think there's a much better chance of getting at least 5 justices.
Okay, I want to talk about the mootness issue, but before we do that, I want to go back to something that you just mentioned. And that's the fact that the court reworded the question that is being addressed here. So, and I'm going off of memory, but in essence, the question that was posed by the plaintiffs is whether or not the Second Amendment protects the right to carry a firearm for self-defense outside of the home. Right. And the court said, well, we're going to actually answer the question of whether or not these individuals had their Second Amendment rights violated by having their applications to get a carry permit denied in New York State, right?
Yeah. I mean, so that it's a little weird because it's not quite the question that was presented by the petitioners. There have been a lot of hot takes over what might be there. I think one of the best analyses, because there are multiple that I've seen, is actually from Professor Josh Blackman, who I think he'd written an article with Reason. There might be some underlying reasons for that. Whether the court, not to get too technical here, but maybe the court wanted to turn this into an as-applied challenge because they want to strike down this particular, carry framework in New York, but maybe they want to leave open that there are other may issue states that, might have workable constitutional frameworks. So maybe they want to do that. Maybe they thought, there's a theory that, maybe they wanted to allow it as an as-applied challenge so that New York could moot the case by granting these petitioners concealed carry permits and just sort of getting rid of it. There's also some theories that by changing the wording a little bit, maybe there's a possibility, or at least some of the justices thought there was a possibility of bringing in like a Justice Kagan onto the issue, maybe getting a 7-justice majority there by limiting it. But at the end of the day, it's really a shoulder shrug. Who knows? We have a case that seems very primed to at least start answering these basic questions.
Absolutely. And so here's my pet theory, by the way, if you want it. I'm not a learned legal scholar like Josh Blackman, but I remember reading the state of New York's response to the cert petition. And one of the arguments that the state of New York had made is that, look, there really isn't a conflict between the various circuit courts. All of the circuit courts have agreed that there's a right to carry outside of the home. It's just that the various courts have differed as to what sort of powers the state government has to interfere with that right in the name of public safety. And so I wonder if the court isn't saying, all right, well, we're not, if the court isn't going to actually try to use that sort of argument, that logic of, look, all of the courts agree that in theory, there's a right to bear arms in self-defense. We're looking at these specific cases to see whether or not New York's denial for these individuals violates that Second Amendment right.
Yeah. I mean, that's certainly interesting, though I don't know. I mean, for listeners who may or may not have been paying attention, I don't know how well that stands up in light of the Ninth Circuit in Young v. Hawaii, where now they've essentially said, no, actually, you don't have a right to carry outside the home in any capacity. It's an interesting hypothetical. I don't know that we'll ever know the reason for it. I mean, maybe we learn later on as the court, once we get an opinion, maybe we start saying, okay, maybe that's why they did it. But, at the end of the day, despite all of these, I think, well-founded propensities to be sort of naysayers and be like, oh, they're going to find a way to get rid of this. They did take the next big step which is to take a meaningful carry case. And I have to be excited about that.
Absolutely. Well, look, and we still have Young versus Hawaii out there. Yep. I mean, that's the other thing is that, the court could still accept Young versus Hawaii when it gets up to the Supreme Court in conference, which probably won't be for a few months. But that case is still alive. And, the court could I'm actually kind of curious to see what the court does with that, because the Ninth Circuit decision was so egregiously bad. Yeah. Is there maybe a two-step process that some of these justices are working on? Again, all hypothetical at the moment. But so let's talk about the idea that, well, maybe New York could moot this case as they did the challenge to the New York City gun law last year. As you say, for the state to go back and retroactively approve these individuals after denying them, that would be, I think, a clear abuse of the system. And to me, that would be just another indication about why this law needs to be changed, because it allows for abuses to take place. That ultimately is, the big question confronting these justices is, does this system in New York, which, by the way, has led to licensing scandals in the New York Police Department, as well as the denial of, law-abiding, responsible gun owners to be able to get their license to carry, is this, again, an infringement on the right to keep and bear arms? And if the state can go back and say, well, you know what, we made a mistake, but now you get to carry a gun, I would argue that absolutely this is a demonstration that this is an abusive system.
It's entirely arbitrary and capricious. So one, you look at the actual petitioners in this case, you have two individuals, at least two individuals who are incredibly responsible, years and years of training. They've done the classroom work. They've almost gone out of their way in the state of New York to say, look, we are responsible, law-abiding citizens. We will jump through any hoops that you put in front of us. Just give us the opportunity. And the state of New York here did what it has done in the vast majority of these instances, which is, and I'm paraphrasing here from Rob Romano. If you're not following him on Twitter, 2A Auto Updates, he'll go through some of these, and the way he always phrases them is the state of New York saying, well, have you tried being robbed more frequently? Have you tried being a victim of crime more often? Because if not, well, sorry. And I think that at its core is the problem. Is that they're not even looking at things like training. Is this person trained? Is this a public safety issue? They're breaking it down to, well, are you actually in danger? We're going to make the decision as to whether you're just, so in need of a gun in public, and not, are you a prepared, responsible gun owner? And it's so arbitrary. It lends itself to, as you've talked about it lends itself to just complete scandals, people just being able to pay off officials in order to get these licenses. And it also lends itself to disproportionately impacting, frankly, poor people of color. You look at whether it's LA County, whether it's New York, overwhelmingly, the people who get these permits are rich, white, well-connected individuals. Sometimes a lot of donors for the county sheriffs. And so it's just so ripe for abuse. It would be funny to see them try to go back and moot it that way, because I think you're right that it plays exactly into the legal hand of, you guys never cared about any, rational cutoff for public safety. This was always about just the state having the power to say, no, pay us enough money or beg us to come exercise your privilege.
Yeah, absolutely. And you make a point that I actually wrote a piece about this yesterday. The left should be opposed to these laws too. Yep. Whether they realize this or not. And I'm actually really looking forward to gun control organizations trying to explain to their allies on the left that, yes, policing is systemically racist. And yes, we need to reimagine policing. But we also need to make sure that police have sweeping authority to decide who gets permission to carry a gun, because they're totally not going to be abusive or racist and discriminatory in that fashion, which is the argument that gun control advocates are making, right? On the one hand, you've got these groups that are proclaiming gun violence is police violence. And they're leaning into the reimagined policing movement. But at the same time, gun control as we know it, I'm not talking about violence prevention programs, I'm talking about gun control, relies on creating new crimes out of thin air that are enforced by armed agents of the state. And this is a system in place in New York that gives incredible power and authority to the very same law enforcement agencies that the left wants to, quote unquote, reform.
Yeah, and it's not just how in practice it works. I mean, we're talking about a history of racist gun control laws, specifically with rights to carry. So it's always interesting to me to see these gun control advocates or states who are defending these laws, bring up these, such and such a state had a concealed carry permit law way back in 18, fill in the blank, whatever. And what they don't tell you is, okay, one, they also permitted open carry, not, needed a permit, but authorized open carry without a permit. And then two, when they started putting these laws into place, overwhelmingly, it was so that they could have the authority to say, oh, well, I see that you are not a white person, so you will not be getting this permit. That overwhelmingly, the racist undertones of these laws is still there, I think, in practice today in what we see just demographically who doesn't get a permit.
Absolutely. So, all right. So, I'm trying to think of some of the questions and comments that I heard. I did have somebody say, all right, well, if the court was really serious about this, why are they waiting until the fall to hear oral arguments? That's just a matter of the schedule, right? Yeah.
So this is pretty late in the term. I mean, theoretically, they could try to throw something into the schedule. But it's already the end of April. I mean, they, by the end of May or June is when they already have all of their opinions out from all of the oral arguments from this term. So you're just running up on some pretty standard deadlines. And especially given that, you look at some of the opinions in lower courts on the same issue, they're coming out to like 100-page majority opinions, and then 100-page dissenting opinions. And I just think for a case of this magnitude at this point, it makes sense. And maybe that was part of the reason they kept relisting it, was thinking, well, if we take it later, then, it's very clear it goes next term and we don't have to squeeze it into this term. So who knows? But yeah, that's not something I would be too concerned with is that they're, waiting on it or something of that.
So if the oral arguments are held, let's say early in the fall, when do you think we might reasonably expect a decision in this case?
So this is where you start getting into the fun game of nobody knows when the opinions will come out in any given term. So realistically, the latest you're going to see it is going to be the last day of the term, which is somewhere around end of May, end of June, 2022. That being said, if they list it for early in the fall, you could see it by early winter of 2022. Again, a case of this magnitude where you're going to have split opinions. You're not going to have, a 9 justice per curiam opinion where they all agree. I just don't see it coming out before 2022. But again, that's not unique to this case or a case of this magnitude. It's not something I would try to read the tea leaves with, be like, oh, they're holding on to it, they're delaying it. At this point, we've waited 13 years since Heller. I think, yes, it hurts to wait another year, but at least we know it's coming.
Yeah. Well, and there are some other cases, the court has now got New Jersey's magazine ban, a legal challenge to that ban, which is going up in conference, I believe, this Friday for the first time. And then I mentioned Young versus Hawaii, that egregiously awful decision by the Ninth Circuit that taken with Peruta versus San Diego, the Ninth Circuit has declared that there is no right to bear arms protected by the Second Amendment. I'm still curious. I realize this is just your opinion. You've got no special insight into the mind of any of the justices on the court. But do you think that now that they've taken the New York Carry case, do you think they just let that go? Or do you think that they still have the potential of taking that Ninth Circuit case, given just how awful that opinion was?
Well, I think realistically, and you saw this similarly sort of after Masterpiece Cake Shop, where if you remember, there were a lot of similar types of First Amendment issues, where what they'll do is, they'll have their core case, which in this case is the New York State rifle and pistol case. And they'll just sort of hold on to all of the other ones pending the decision in the New York State rifle and pistol. And then I would imagine that, whenever that opinion comes out, which, we both hope and think should appropriately be, that this sort of may issue good cause requirement is impermissible, that there is some right to carry outside the home. I would imagine you'll see what are called, a lot of people refer to them as GVRs. So they'll grant the case, vacate the opinion, and remand it to the Ninth Circuit, basically saying, you done messed up, see our opinion in this recent Second Amendment case, fix it. And then theoretically, the Ninth Circuit should reevaluate that case and say, yes, whatever, that there is a right, Hawaii fix this, and order Hawaii to fix it. Sometimes that doesn't work. Theoretically, you could still see the Ninth Circuit a year or 2 years from now saying, no, we still think, even in light of this recent Second Amendment case, that this is still permissible, and then the Supreme Court might have to slap that down again. But that's more realistically what I would expect. I wouldn't expect them to take both of those cases or combine them. I think it's pretty clear cut in New York that they can just take the rest of these carry cases after that opinion and say, look, see our opinion, fix it, do the right thing.
So even with the revised question, the sort of, slightly narrower focus, you think that the court still has the opportunity to issue an opinion that will impact more than just the New York carry laws?
I would imagine so, especially because this would be the first time that the court is dealing with the right to carry outside the home, that there will be some aspects of that opinion that so heavily touch on the right, above and beyond just saying, no, these, four plaintiffs, these four individuals had a right, you have to grant it to them. I would imagine that the broader scope of the opinion would be enough in the way that they flesh out why those individuals have that right, that there would be enough there to essentially send Young v. Hawaii back to the Ninth Circuit to say, look, see what we said, don't make us come back here. And maybe the Ninth Circuit doesn't take the hint, maybe they do, but I think realistically, that's generally how the court handles these types of issues. All
right. Fingers crossed. Amy Swear, listen, I appreciate your insight and your expertise. Thank you so much for coming on the show today. It's always good talking with you.
Thank you so much for having me. And hopefully we're back in the future talking about the great opinion that came out in the carry cases.
Absolutely. I appreciate Amy joining us on the program. And we'll be talking with her again, I'm sure well before oral arguments are held in New York State Rifle and Pistol Association versus Corlett. Something's going to come up here, whether it's Biden's executive orders, whether it's new gun-controlled legislation in Congress, maybe even some pro-gun legislation in Congress. But right now, let's turn our attention to today's Armed Citizen story, our good deed of the day, our recidivist report. And what a doozy this one is. Ypsilanti, Michigan, boot camp and probation ordered for a man accused of repeatedly shooting at a home in Ypsilanti Township. That's right. Gun control activists believe that you and I and other legal gun owners should go to federal prison for a year for transferring a firearm to our neighbor or our best friend without putting them through a background check. Meanwhile, you've got violent criminals who are repeatedly shooting at homes. And the sentence? Come here. Hold out your hand. Don't do that again. Unbelievable. Martez Adarian Marne Ayers, sentenced yesterday to 3 years of probation in boot camp in the Michigan Department of Corrections in a string of drive-by shootings last summer. The 22-year-old pleaded no contest back in February to 4 felony counts associated with a rash of shootings that erupted September 1st through the 3rd in Ypsilanti Township. He pleaded no. Are you ready for this? God, it's bad enough, by the way, that this jackass gets probation for shooting at a house. But here are the actual charges he pled guilty to. Discharging a firearm in or out of building, discharging a firearm from a vehicle, possession of a firearm by a felon, and possession of ammunition by a felon. If this case had been referred to federal court, Ayers would be looking at a minimum of 5 years in federal prison with no early release. Well, early release after 85% of his sentence has been served. Instead, he's not going to prison at all. This is amazing. His sentencing was handed down by Washtenaw County Trial Judge Carol Kuhnke, who was filling in for assigned Judge Patrick Conlon. It was delayed several weeks while the court confirmed that boot camp was an option and available. The charges stem from 10 shooting incidents over a 3-day period, primarily targeting one home. During one of the incidents, a 19-year-old man sitting on the front porch of the home was shot in the leg. But again, none of that matters to the criminal justice system because Ayers is going to have to go to boot camp. And he's going to get 3 years probation. And the most the toughest part of his sentence, 25 hours of community service. Yeah. Ayers, by the way, credited for 230 days served in jail as he was awaiting trial. That's the only time he's going to do. But yeah, let's talk about Governor Whitmer, why we need more gun control. Let's talk about banning legal gun owners from possessing firearms in the state capitol. Let's talk about all of these non-issues in the state of Michigan, so that we don't have to talk about Martez Adarian Marne Ayers and his BS sentence for shooting someone and shooting at a home 10 different times over a 3-day period. Unreal. And by the way, local news story, right? Cases like his, never going to show up in the national news. Why? Well, for one thing, there are too many of them for the national news to cover, because that is what happens in our criminal justice system day in and day out. Even if you don't like guns, even if you hate the Second Amendment, the idea that slapping another gun control law on the books is got to fix things, you're insane if you think that that's the case. All right, turning our attention to our armed citizen story from Ashtabula County, Ohio, where a homeowner shot a 26-year-old armed robber in the chest. Will not be facing any charges for that because it was a justified shooting. Sheriff William Nemi said that the deputies were called out on Thursday evening just before 8 p.m. for reports of a shooting. Preliminary investigation determined that the man and two other individuals, the man who was shot, two other individuals, went to the home to retrieve some property. The man went into the home with a gun and demanded his property. A short time later, witnesses who stayed outside heard a series of gunshots before the man ran out with his hand on his stomach. Sheriff said investigators believe the man fired at the homeowner before he was shot. According to the sheriff, last report, the man listed in critical condition, is stable, is expected to recover. This would appear to be a clear-cut case of self-defense. Even if you have a property dispute, probably the worst way to handle it is to grab a gun and then try to break into somebody's home to get your stuff back. But that appears to be at least the attempted justification. We don't even know whether or not the individual's property was actually inside that home, just that was the reasoning he used to engage in the home invasion. And finally today, our good deed of the day from Avon, Minnesota, where the local police chief, in the right place at the right time, willing and able to do the right thing to help save a man and his property from a fire. This was last Thursday afternoon, about 1:30 in the afternoon. Avon Police Chief Corey Nellis on patrol when he saw black smoke coming from an area south of town. So he decided to investigate. He's also, by the way, a volunteer firefighter. Found a fire in a wooded area, and he could hear somebody yelling for help when he got out of a squad car. James Dean, 73-year-old, who owns the property, was laying there on the ground. The ground around him was actually on fire. The chief ended up calling county dispatch for help. He was not able to get to James Dean on his own. Within a short period of time, the Stearns County Sheriff's Office, Avon Police Department, Minnesota State Patrol, Avon Fire, Albany Fire Departments all arrived. Dean was rescued from that blaze, taken to a St. Cloud hospital with burns to his legs and arms. Dean told authorities this was supposed to be a controlled burn. Basically, he had, gathered up a small pile of sticks, lost control of it. There's a storage trailer that was severely damaged, along with minor damage to Dean's home. Several acres also burned, but thankfully, again, Dean is going to recover thanks to the quick response of Corey Nellis, the police chief there in Avon, Minnesota. So in the right place at the right time, willing and able to do the right thing. We thank you, sir, for your very good deed. That is all the time we've got for you on this edition of Bearing Arms Cam and Company. Want to thank you as well. If you are a VIP subscriber to BearingArms.com, I certainly do appreciate it. If you're not yet a VIP subscriber, well, I would encourage you to do so. You can just go to BearingArms.com/subscribe. You can use the code GUNS and get 25% off of your membership. It's going to give you exclusive access to columns, commentary, analysis, live chats, and more. And it also helps support us doing the work that we do each and every day to bring you the latest Second Amendment news and information, as well as to fight for our right to keep and bear arms. So thank you again for your support. If you are a new subscriber, if you're a continued subscriber, I really do appreciate it. Also want to let you know that you can subscribe to Town Hall Media on YouTube. That way you'll never miss one of these programs. Or you can go to rumble.com, look for Bearing Arms Cam and Company. You can also find us on Apple Podcasts, Amazon Podcasts, Spotify, SoundCloud, Stitcher, the townhall.com podcast page. We do try to make it easy for you to find the program. We certainly do appreciate you watching, listening, and spreading the word. We will be back tomorrow. But until then, be well, be safe, and be free.